Good day to each and everyone, ladies and gentlemen. Welcome to the first video presentation for the subject Fundamentals of Criminal Investigation with Intelligence. No? It is the basic subject under Crime Detection and Investigation Division, which is provided under Chat Memo number 5, series of 2018, in accordance with the provision of Republic Act number 11131 and Republic Act number 7722 or the Higher Education Act of 1994, no? At ano nga ba yung pong ating pag-uusapan dito po sa chapter 1 ng subject na ito? Ang ating pag-uusapan po dito ay tungkol po sa rights of the accused, yung karapatan ng isang akusado, which is very important for you to know as a future law enforcer or investigator, no? So that you will not violate the rights. It also includes victims' welfare, no? And in relation to criminal investigation. Okay, so as a law enforcer or as a future investigator on case, you should be sensitive, no, to the rights of the accused or to a person who is under custodial investigation, no? So a person whom you arrested, no? Or to include the victims para hindi naman nila sabihin na palagi na lang na nakakalimutan ang victim, no? Pagka meron pong nangyaring krimen. Okay? Yan. So objectives. At the end of the lesson, the student should be able to apply the knowledge on Republic Act number 7438. No? So after you finish this subject, and you should be able to apply Republic Act number 7438 in every aspect of life, as well as Republic Act number 9745, an Article 3 Bill of Rights of the 1987 Philippine Constitution, no? And to include the United Nations Convention on Human Rights in the course of investigation. You should also be able to exemplify and implement the appropriate laws pertaining to the welfare and protection of victims, especially, of course, if you will become now as a police officer. You should also be able to recognize and implement the rights of the accused and victims' welfare. Okay? Ayan. So ano pang hinihintay nyo? Umpisahan na po natin, no? At umpisahan natin yon doon po sa Bill of Rights. So yun pong karapatang pantao ng bawat mamamayang Pilipino. Okay? So in segment 1, we will present to you the rights of the accused under Article 3 or Bill of Rights of 1987 Philippine Constitution. Okay? So hindi lang po ito tumutukoy po sa karapatan ng akusado, kundi i-discuss na rin natin o papasadahan natin yung buong Bill of Rights, ladies and gentlemen. Okay? So this is very important, no? For you to know as a future law enforcer or investigator to be sensitive of everybody's right. Okay? So ano nga ba yung nasa Section 1? Section 1 provides that no person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of laws. So bilang tagapagpatupad ng batas, later on, ito po'y napaka-importante, napaka-simple, sabi dyan, walang sino man ang dapat tanggalan ng karapatang mabuhay. Huwag kayong papatay. Di ba? Karapatang maging malaya. So hindi mo pwedeng arestuhin na lang yung tao pag naglalakad dyan sa kalsada sapagkat ang isang tao ay meron pong kalayaan ibinibigay ang ating konstitusyon. Kapag wala sa tamang proseso, yung pagtanggal mo sa kanyang karapatang maging malaya, definitely ikaw pa ang kakasuhan. No? Yan. So you have the rights, or every person of the right to liberty, kalayaan, and the right to property. Okay? So hindi mo pwedeng tanggalin yung kanyang tatlong karapatan na yan na wala pong karampatang paglilitis o yung tinatawag pong due process. Okay? So kung nakagawa ng krimen, susundin mo yung due process. Ngayon po sa pagtanggal niya ng karapatang maging malaya. Yan. Karapatang magmay-ari ng ari-arian. Karapatang mabuhay. Diba? Oh, that is protected by our Constitution. That is provided under our Constitution. that all persons have the right to life, liberty, and property, and that should not be taken without due process of law. Section 2 provides the right of people to be secure in their persons, no, sa kanilang pagkatao, houses, papers, and effects against unreasonable searches and seizure. So hindi ka lang pwedeng basta-basta pumasok sa bahay ng isang tao at magsi-search ka doon, basta-basta makapkapan mo na lang ang isang tao, wala po. Or wala pong sino mang may karapatang gawin yon, no? Ayan. Kasi sabi dito sa Section 2, lahat ng tao ay meron pong karapatang maging secure sa kanilang sarili, sa kanilang bahay, no? Sa kanilang mga dokumento at effects against unreasonable search and seizure of whatever nature and for any purpose shall be inviolable or shall not be violated. And pwede bang mag-search ang isang pulis? Yes, considering that there should be a search warrant. But, sabi pa dito, no search warrant or warrant of arrest shall issue upon probable cause. O walang dapat warrant of arrest or search warrant ang i-issue ng huwes pag wala pong probable cause. Okay? To be determined personally by the judge after examination under oath in the formation of complainant and witnesses, he may produce in particularly describing the place to be searched and things or person to be seized. So tatandaan niyo po yun. Pagka kayo po ay nagpulis, hindi po kayo basta-basta pupunta sa isang lugar, mag-search na lang. Basta may nabalitaan kayo na may ganito, ganire, tapos pupunta kayo doon to search, okay? Hindi po pwede yun, no? Sapagkat na ilagay po sa ating konstitusyon, no, na wala pong sino man ang dapat ma-search, okay, ma-aresto kung wala pong search warrant or wala pong warrant of arrest. Okay, yan. So yung mga exemption, saka na natin i-discuss yung tinatawag na warrantless arrest circumstances. But generally, all people have the right to be secured in their person, houses, papers, and effects. And no unreasonable searches and seizure of whatever nature and for any purpose shall be inviolable. Okay? So ano ang kailangan bago makasecure ang pulis ng search warrant? Kailangan po ng probable cause. Kanino nagsisecure ng search warrant or warrant of arrest ang isang pulis? Sa judge. Paano naman titingnan ng judge kung merong probable cause? No? Kailangan po na i-produce yung pong nag-aakusa, yung pong witnesses, yung complainant. Yan, no? Okay, so those are the two primary rights. We have also number 3 right. Number 3, paragraph 1, the privacy of communication and correspondence. Yung mga pasilip-silip ng text dyan, meron po tayong karapatan na maging pribado sa ating communication at correspondence o sa sulat po yan, shall be inviolable except upon lawful order of the court or when public safety or order requires otherwise as prescribed by law. Tandaan niyo po yan, meron po tayong rights of privacy, of communication, and correspondence. Hindi na lang basta-basta pwedeng tingnan yung text, yung chat sa messenger ng police. No? Yan. Then, any evidence obtained in violation of preceding section, yung pong mga nauna ng section 1 and 2, shall. Sabi dyan, no? Any evidence obtained, lahat ng ebidensya na nakuha in violation of preceding section shall be inadmissible. It cannot be admitted as evidence in court or in any proceeding. So, napakalinaw, ano? Kapag ka na-violate mo po yung section 1, section 2, no, ng konstitusyon, lahat po ng ebidensya na iyong nakalap ay hindi pwedeng gamitin ebidensya laban sa isang tao sa korte. Dahil yun po ay mga product ng unreasonable search and seizure. Okay? Susunod. No law shall be passed abridging, no, nangingialam doon po sa freedom of speech, no, or destroying the freedom of the speech, of expression, or of the press, or the right of people peaceably to assemble and petition the government for redress of grievances. Okay? Then, susunod po, no? Section 5 provides, no law shall be made respecting an establishment of religion or prohibiting the free exercise thereof. So lahat po ng tao ay may karapatang mamili ng kanyang sariling relihiyon. Kahit pulis hindi mo pwedeng pigilan ng isang tao kung ano man ang kanyang gustong religion. Okay, yan. The free exercise and enjoyment of religious profession and worship without discrimination or preference shall forever be allowed. No religious test shall be required for the exercise of civil or political rights. Okay, so ang ating gobyerno po ay hindi po pwedeng pakialaman kung ano man yung gusto mong religion. So nakasaad po sa ating Section 5 ng 1987 Philippine Constitution. Okay, so kung kahit anuman ang iyong relihiyon bilang isang pulis, ay dapat mong respetuhin ang relihiyon ng bawat kapwa-tao mo. Okay, hindi porket iba ang relihiyon na arestuhin mo na. Di ba? So napakalinaw naman. Section 6 provide the liberty of abode, manirahan, no, and of changing the same within the limits prescribed by law shall not be impaired except of unlawful order of court. Neither shall the right to travel be impaired except in the interest of national security, public safety, or public health as may be provided by law. So yung pong kalayaan nating mamili kung saan natin gustong manirahan, kaya gusto mong lumipat ay hindi po pwedeng pigilan ng ating mga batas. No? Ayan, so meron tayong kalayaang mamili kung saan natin gustong manirahan at walang batas dapat na maipapasa na taliwas dito sa kautusan ng konstitusyon na ito. Susunod, Section 7 provides the right of people to information on matters of public concern shall be recognized. Access to official records and to documents and papers pertaining to official acts, transactions, or decisions, as well as government research data, no? Research ng gobyerno, ay may karapatan po ang bawat mamamayan, no, na mga makaalam nun, no? Subject to such limitation as may be provided by law. So we have access to information on public concerns. Take note, no? Section 8 provides the right of people, including those employed in public and private sector, to form union. Meron tayong karapatang bumuo ng union kung tawagin sa mga pribadong sektor, association, society for purpose not contrary to law. Okay? So meron tayong karapatang bumuo ng ating mga asosasyon, mga samahan, no? Para protektahan ang ating karapatan. Pero dapat yung pong grupo na yun ay naitayo na hindi naman taliwas sa mga batas. Okay? Baka naman binuo mo yon dahil gagawin mong or gagamitin mo for kidnap or ransom, dahil hindi naman po pwede. Ayan, no? Section 9 provides that private property shall not be taken for public use without just compensation. Ang inyong mga pribadong ari-arian ay dapat hindi pupunin para sa pampublikong gamit nang wala man lang kabayaran. So, ibig sabihin, pagka kukunin po ng publiko, ay meron pong bayad. Okay? Section 10 provides that no law impairing or damaging the obligation of contract shall be passed. So that is self-explanatory, no? Walang batas na dapat maipasa na kung saan ay dinadamage. No? Ito yung pong obligasyon sa kontrata. Section 11 provides that free access to courts and quasi-judicial bodies and adequate legal assistance shall not be denied to any person by reason of poverty. Kahit na ikaw ay mahirap, ay hindi po dapat ipagdamot ng ating gobyerno yung pong iyong kalayaang magkaroon ng iyong sariling abogado at magkaroon po ng access sa korte at sa quasi-judicial bodies. Yung mga quasi-judicial bodies yan, no? Hindi po sila court, but their function is the same as the function of the court because they will determine, no? Or they will be the one to decide whether who is guilty or not guilty. Kaso nga lang para sa mga kasong administratibo. Section 12. This is very important in investigation, ladies and gentlemen. Ito yung isa sa importante sa investigation maliban sa Section 1, Section 2. Itong Section 12. This is very important. Okay, fine. Any person under investigation, okay? So, napakalinaw, ano? Any person under investigation for the commission of an offense shall have the right to be informed of his right. Tatandaan, ang isang tao na iniimbestigahan mo ay meron siyang karapatan na malaman ang kanyang karapatang manahimik at magsawalang kibo. Okay? And to have competent and independent counsel of his own choice. So meron siyang karapatang manahimik at magsawalang kibo, kailangan mong sabihin yon. Meron din siyang karapatang magkaroon ng sariling abogado, ng kanyang sariling pili. So pipili siya ng abogado niya na gusto niya. Kalayahan niya yan. If the person cannot afford the services of the counsel, he must be provided with one. So kung wala pong abogado, kailangan bigyan ng pulis ng abogado yung pong akusado. O ikaw pa mamang problema, no? Na pulis. Take note. These rights cannot be waived except in writing and in the presence of counsel. Hindi po pwedeng i-waive, no? Yung pong karapatan na yan, maliban na lamang kung yan po ay may kasulatan at siyempre yung kasulatan na yun, nilagdaan mo at nilagdaan ng abogado na kung saan yung abogado ay andun nung lagdaan mo yung pong waiver. Okay? So take note, no? Any person under investigation for the commission of an offense have the right to be informed of his right. So kung makikita nyo sa mga movies, at ito po'y gagawin ninyo, no? Ayan. So sa inyong mga bahay, kasi bawal nang lumabas, ito po yung gagawin ninyo, no? Dito po sa ating slide number 8, this is your first activity. I-video nyo ang inyong sarili, mga kapatid, at anong gagawin? I-video nyo ang inyong sarili, tawagin nyo ang inyong mga kakilala sa kapitbahay, kung mari aarestuhin nyo siya, i-inform nyo siya ng kanyang karapatang magsawalang kibo. Di ba? Meron siyang karapatang manahimik at magsawalang kibo. Meron din siyang karapatang kumuha ng kanyang sariling abogado, ng kanyang sariling pili. Okay, so ito po yung napapanood nyo, mga kapatid. I am Police Officer 1 Sammy Stoke. I am arresting you because of raping Maria. You have the right to remain silent. Ganon, no? You have the right to counsel of your own choice. If you cannot afford one, the government will provide one for you for free. Understood, man? Ganon. Okay, kapag Ilocano, Ilocano mo. Di ba? Ayan. So, your first activity, ladies and gentlemen, no, is to conduct a video on the proper way on how to arrest the person, no, and or to inform the person who is under custodial investigation. Okay, so yun po yung activity niya. Then, paragraph 2, no torture, force or violence, threat, intimidation, or any means which vitiate the free will shall be used against him. Secret detention places, solitary incommunicado, or other similar forms of detention are prohibited. So tatandaan, hindi po dapat kayo mag-torture. Pag nagpulis kayo, huwag kayong manorture para lang mapaamin yung isang tao. No? Walang pamumwersa or pamimilit. Okay? Walang pananakit. No? Wala pong pananakot na nangyari. Yan, threat. No? Or yan po, intimidation na ginawa. No? Na kung saan yun po ay makakasira doon po sa kanyang free will. Yan. So, bawal din po yung pagkukulong sa mga detention facilities or yung pong solitary confinement or incommunicado. Bawal yun, no? Then, paragraph 3 provides any confession or admission obtained in violation of these or section 17 hereof shall be inadmissible as evidence against him. Ibig sabihin, kapag pinilit mo yung pong isang tao na magsalita, tinorture mo siya para magsalita, no? Pinilit mo siya, kaya po siya nagsalita, then hindi rin po pwedeng tanggaping ebidensya sa korte. Okay? So, inadmissible din po yun, mga kapatid. Why? Because that is a violation against right to self-incrimination. Wala kasing tao na pwedeng piliting magbigay ng testimonya laban sa kanilang sarili. Okay? Then, paragraph 4 provides, the law shall provide for penal and civil sanction for violation of this section, as well as compensation to and rehabilitation of victims of torture or similar practices and their families. Okay, so maliban po doon po sa pagbabayad mo, kung ikaw ay nag-torture, ano, meron kang penalty, tatanggalin ka pa sa serbisyo, may administrative case, may criminal case ka, may civil case ka pa. Pakukulong ka sa criminal case, pagbabayarin ka sa civil case, tatanggalin ka sa serbisyo sa administrative case. So tatandaan niyo po ito. Ano? Article 3, we have section 12. Paragraph 1 to 4. Maliban sa section 1 and 2. Okay? So these are the very important things that you should know, especially when you will become investigators or law enforcers. Okay? So additional, no? All persons except those charged with offenses punishable by reclusion perpetua, that is 20 years and 1 day to 40 years, when evidence of guilt is strong, shall before conviction be bailable. Ibig sabihin, basta ang penalty po ay hindi po reclusion perpetua, ay pwede pong magpiyansa. Yun po ang sinasabi dyan, by sufficient sureties or be released on recognizance. Pag sinabi nating recognizance, ito po yung ipagkakatiwala yung pong akusado doon po sa isang tao na meron pong mataas ang probity at integridad doon po sa kanilang lugar. Usually barangay officials, no? Pero hindi lang naman barangay officials, as long as the person have the highest degree of probity and integrity. Okay? Yun po yung release on recognizance. Kung wala talaga siyang ari-arian. O yan. So the right to bail shall not be impaired even when privilege of writ of habeas corpus is suspended. Excessive bail shall not be required. So tatatandaan nyo, no? Meron pong karapatan ng bawat tao na magpiyansa basta ang penalty hindi po reclusion perpetua. Section 14, paragraph 1 provides that no person shall be held to answer for criminal offense without due process of law. Okay? So kung hindi po dumaan sa tamang proseso, wala dapat parusahan doon sa isang krimen na hindi naman niya ginawa. Yan po yung tinatawag na procedural due process. Paragraph 2 provides that in all criminal prosecution, the accused shall be presumed innocent. Take note, kapag ang isang tao ay naaresto, no, at kinasuhan, yung pong isang tao na yon is considered innocent. Presumed innocent. So treat that person as an innocent person. Inaresto mo, i-treat mo siya bilang innocenteng tao. Take note of that. In all criminal prosecution, the accused shall be presumed innocent. Akusado na siya noon. Paano nung inaresto mo? Suspect pa lang siya. You treat him as an innocent person. Why? Because a person, okay, or an accused is considered or presumed innocent until the contrary is proved and shall enjoy the right to be heard by himself and counsel, to be informed of the nature and the cause of accusation against him, to have a speedy and impartial trial. Pag sinabi nating impartial, walang kinikiling ang paglilitis, di ba? To have a speedy, mabilisan, and public trial, to meet witnesses face to face, okay? And to have compulsory process to secure the attendance of witnesses and production of evidence in his behalf. However, after arraignment, trial may proceed notwithstanding the absence of the accused, provided that he has been duly notified and his failure to appear is unjustifiable. Okay, so pagkatapos na po ng arraignment, yun po yung time na kung saan yung pong akusado, ibabasahan po ng sakdal, tatanungin kung siya po ay guilty or not guilty. Yun po yung tinatawag natin arraignment, ladies and gentlemen. Arraignment. No? Pagkatapos ng arraignment, so pwede na mag-proceed yung trial kahit wala yung accused. Ang tawag doon ay trial in absentia, ladies and gentlemen. No? Yan. Okay. Let us proceed to the next section. Section 15 provides the privilege of writ of habeas corpus shall not be suspended except in cases of invasion of rebellion when public safety requires it. Writ of habeas corpus, yung kailangan mo makita yung pong body of the crime. Diba? Section 16, all persons shall have the right to speedy disposition. Mabilisang disposition of their cases before all judicial, quasi-judicial, and administrative bodies. Hindi dapat masyado matagal ang paglilitis. Diba? Section 17, no person shall be compelled to be witness against himself. Tatandaan niyo po ito. Walang sino mang tao ang dapat pilitin na magbigay ng testimonya laban sa kanyang sarili. Ito po yung tinatawag na right against self-incrimination. You cannot incriminate yourself. Section 18, paragraph 1 provides that no person shall be detained solely by reason of his political belief and aspiration. Walang sino mang tao ang dapat pong i-detain or ikulong dahil lamang doon po sa kanyang paniniwalang political at aspiration. Second, second paragraph under section 18, no involuntary servitude in any form shall exist except a punishment for a crime whereof the party shall have been duly convicted. So walang sino man ang dapat pilitin na magsilbi or magtrabaho, kahit yung mga pulis, pagtatrabahuin mo yun nasa kulungan, hindi pa naman convicted, sabi dyan, hindi pwede. Okay? Yan. No involuntary servitude. Section 19, paragraph 1 provides excessive fines shall not be imposed. Wala dapat excessive or sobrang fines, no? Na dapat ibigay ang korte, nor cruel or degrading or inhumane punishment inflicted. Neither shall death penalty be imposed unless for compelling reasons involving heinous crimes, but that was already suspended, The Congress hereafter provides for it. Any death penalty already imposed shall be reduced to reclusion perpetua. Paragraph 2, the employment of physical, psychological, and degrading punishment against prisoner or detainee or use of substandard or inadequate penal facilities under subhuman conditions shall dealt with by law. Yun po yung sinasabi ng konstitusyon. Pero sa totoo, ewan po natin, no? Yan. Section 20 provides that no person shall be imprisoned for debt or non-payment of a fault tax. So wala pong tao na dapat makulong dahil lamang sa utang or dahil sa hindi pagbabayad ng buwis. Okay? So nakita nyo, maliban na lamang kung may pambayad ka, niloko mo yung gobyerno, magkaiba yon. Yung nanloko ka, merong fraud na nangyari, doon po sa wala ka talagang pambayad. Pero wala pong nakukulong sa utang. Andinaw po. Okay? Pero pagka ikaw po ay nanloko, sabi mo wala kang pera, yun naman pala, meron naman pwedeng ibenta pa, nanloko ka, then ibang usapan na po yan. Okay? Then section 21, no person shall be twice put in jeopardy of punishment for same offense. If an act is punished by law and an ordinance, conviction, or acquittal under either shall constitute a bar to another prosecution for the same act. Isa lang yung ginawa niya, kinasuhan mo, na-dismiss yung kaso, kakasuhan mo ulit, pwede pa ba? Hindi na. Pwedeng iapila, pero hindi mo pwedeng kasuhan ng 2 beses, doon sa iisang krimen. Pag na-dismiss na, hindi na pwedeng filean ulit. Tatandaan, So, isa lang yung ginawa niya, dismiss, o kaya naman convicted siya, lang naman kakasuhan mo sa pangalawang beses. 2 kaso, 2 kaso sa iisang ginawa niya. That is double jeopardy ang tawag. Okay, bawal po yun. Yan. Section 22 provides no ex post facto law or bill of attainder shall be enacted. Okay, so ano ba yung ex post facto law? A law which punishes an act which the act was already done prior to the passage of law. Okay, ex post facto. Okay, kasi isa sa characteristics ng batas, diba, prospective paabante. Wala po dapat paatras, sabi diyan, walang ex post facto law. For example, nangyari po yung krimen sa Camera Hidden Co 2007, wala pa naman noong Anti-Video and Voyeurism Act. Diba? So hindi po pwedeng kasuhan noong Anti-Photo and Video Voyeurism Act, yung pong kanyang ginawa, kasi wala pang batas na ganun noon. Kaya po, mas magaan po yung na-file sa kanya. Why? Because there is no ex post facto law unless if the law is in favor to the accused. So all laws should be prospective, paabante. Example, na ipasa yung batas ng 2020, may apply siya 2021, 2022, 2023. Yan. Okay? Pero hindi pwedeng paatras. Ano naman po yung Bill of Attainder? Yung pong batas na kung saan ikaw po bibigyang parusa ng wala pang paglilitis. Okay? So bawal po yun, na ipasa ng Kongreso. Okay. So yun po yung 22 na rights under Bill of Rights. So take note of the most important part, yung pong ating discussion, ladies and gentlemen, especially doon po sa Section 1, Section 2, and Section 12 of the 1987 Philippine Constitution. Okay, so let us check the history of rights of the accused, arrested, detained, or under custodial investigation. Under 1935 Philippine Constitution, Article 3, Section 17, Paragraph 1, no, 1935, ano? So, meron na pong karapatan ng akusado doon. Why? Sabi diyan, in all criminal proceeding, the accused shall enjoy the right to be heard by himself and the counsel. So, doon po sa 1935 Constitution, ano, history na po yan, na Constitution, no? Kasi ang ina-apply ngayon is 1987, na ina-amend pa. Before, there is already rights given to the accused. They have the right to be heard. May karapatan silang madinig ang kanilang kaso, no? Yung kanilang panig at yung kanilang abogado sa korte. Okay, so ibig sabihin may paglilitis na. Yan, no? So in all criminal proceeding, the accused shall enjoy the right to be heard by himself and the counsel. 1935 yun, ano? Under 1973 Constitution, o yung tinatawag na Marcos Constitution, it is also provided under Article 3, Section 20, that no person shall be compelled to be a witness against himself. Tama? That any person under investigation for the commission of an offense shall have the right to remain in silence, to have counsel, and to be informed of such rights. No force, intimidation, or any means which vitiate the free will shall be used against you. Any confession obtained in violation of the section shall be admissible as evidence. So as early as 1935, meron na pong constitution na magpoprotekta sa karapatan ng isang akusado na madinig muna yung kanyang panig at yung pong kanyang abogado. 1973, nadagdag na po na dapat wala pong tao na pwedeng pilitin na maging witness laban sa kanyang sarili. Diba? Yan. Then, yun po ay nadagdagan pa doon po sa 1987 Philippine Constitution, Article 3, Section 12, Paragraph 1 to 4. Diba? Ano nakasaad doon? Any person under investigation of the commission of an offense shall have the right to be informed of his right to remain in silence and to have a competent and independent counsel preferably of his own choice. If the person cannot afford services of the counsel, he must be provided with one. So meron na pong improvement. Meron nang nadagdag. Okay? Ano ang nadagdag dito? From 1973, okay, ano ang nadagdag? Dito po sa 1987 na pwedeng mamili yung pong isang taong akusado ng kanyang sariling abogado. Di ba? Yan. Then it was also emphasized herein in 1987 Philippine Constitution that the right cannot be waived except in writing and it should be signed and in the presence of counsel. Okay, so that is the history of the rights of the accused. 1935, meron na. 1973, meron ng karapatan ng akusado. 1987, binigyan diin yung karapatan ng bawat accused. Okay? Ayan. So, saan nga ba galing yung pong right to be informed, right to remain in silence, no? Right to have a competent and independent counsel? Yung po ay product ng tinatawag nating sociology of law wherein researchers try to study laws, origin of laws. Are these laws are good in other countries and they will get that and apply here in our country, no? Yan po. So, sociology of law. Okay, product of sociology of law, yan, na naging criminal jurisprudence. Okay? Decision ng Supreme Court doon sa ibang bansa, inadapt ng Pilipinas, yon ginagamit hanggang ngayon. Sinabatas, yan. So, the rights of the accused or a person arrested, detained, or under custodial investigation started because of the case of Ernesto Miranda versus the state of Arizona, which happened in 1966. No? So it originated from American jurisprudence or the decided cases in the United States of America. It is a case of Mr. Ernesto Miranda, a Latino, who was accused of kidnapping and rape in the state of Arizona. The Arizona police interrogated him exhaustively, leading to his confession. Okay? Talagang ginalingan yung pag-interrogate, sobrang tagal ng interrogation, di ba? Na-exhaust, no? So, anong nangyari? Umamin. Based on his confession, he was charged, tried, and convicted. Appeal of his conviction was made before the Arizona Supreme Court, but his conviction was affirmed. The appeal was then elevated to U.S. Supreme Court, buong U.S. na, no? Where there was a reversal of the decision and he was acquitted on constitutional grounds. So, na-acquit po si Ernesto Miranda. So, napaka-importante po nitong pag-inform ng pong karapatan ng isang tao. Dahil yun po'y pwedeng ma-acquit yung isang kaso kahit ang ganda ng ebidensya na inyong nakalap, pero hindi mo alam yung karapatan ng isang tao na inaaresto mo ay pwedeng ika-dismiss ng kaso. Okay? So, parang itong nangyari nga, doon po sa kaso ni Ernesto Miranda versus the State of Arizona. Ang galing ng pulis, maganda yung evidence, no? Convicted doon po sa lower court. Pero pagdating na sa Supreme Court, nabaliktad po yung pangyayari, no? Because of constitutional grounds, because of what we call as procedural due process. Hindi po sinunod ng pulis ang proseso. Dahil siguro hindi alam yung proseso. Di ba? Yan. Or alam, pero nakaligtaan. Ganon. At wala pang standard noon. Ngayon, meron na. No? So it was in this case that U.S. Supreme Court laid down the constitutional rights of the accused during the custodial interrogation. This constitutional right was also incorporated in 1973 Philippine Constitution and later in 1987 Philippine Constitution. This is known as Miranda Rule. Tandaan niyo po, no? From the case of Ernesto Miranda versus State of Arizona, anong tawag na? Nung nailagay po sa ating konstitusyon at sa ating batas, Miranda Rule, no? Miranda Doctrine, or yung warnings, no? Ay tinatawag na Miranda Warning. Yan. Yung karapatan na nakapaloob naman dito sa Miranda Rule, Doctrine, or Warning is called as Miranda Rights. Yung karapatan, Miranda Rights. Okay? Yan. Yung doktrina, Miranda Doctrine, Rule, or Warning. Okay? So what are the rights of a person under custodial investigation under this case? No? So the rights of person under custodial investigation are as follows. Ito po yung mga rights na in-specify ng Supreme Court ng United States of America because of the case of Ernesto Miranda versus the State of Arizona na inadapt ng ating bansa, nilagay pa sa ating konstitusyon. So anong mga karapatan? First, the right to remain in silent and think that he or she may say may be used against him in any court of law. The right to have a counsel preferably of his own choice, and if he or she has none, hindi niya ma-afford, then the government must provide one for him. Right to be informed of the nature and charges against him of whatever he says may be used for against him. So yun po yung tatlong karapatan na nakapaloob yun po sa Ernesto Miranda versus State of Arizona. So kailangan mong i-inform yung kanyang karapatang manahimik at magsawalang hibo. Kailangan mo ding i-inform yung kanyang karapatang magkaroon ng sariling abogado. Yan, at kailangan i-inform mo ito. Okay? Ayan. Take note. Okay? Take note, ladies and gentlemen. These rights could be validly waived in writing in the assistance of a counsel in order that the ensuing confession be admissible in evidence. The confession must also be in writing, signed, and sworn by the accused. In Miranda versus Arizona case, the court addressed the question how to enforce the suspect rights to the counsel and rights against self-incrimination. The court concluded that police officer must specifically inform the suspect of these rights and inform them that if they give up these rights, their statement can be used against them. Okay? So, ito nga po yung binibigay kong gagawin ninyo, no? Yung kunwari aarestuhin nyo yung pong kapatid nyo, tatay nyo, di ba? Then you will inform him of his or her rights. Okay? So, dapat tama, no? Yan. So, meron kang karapatang manahimik at magsawalang kibo sa salita ninyo. Okay? Ayan. Then, kailangan ay i-video ninyo yan. Then gawa kayo ng inyong YouTube channel, no? Or kung maiksi naman, pwede niyong i-forward doon po sa inyong Google Classroom or gumawa kayo ng YouTube channel, send niyo yung link doon po sa ating GC, no? Ayan. So, sample, meron pong isang tao na suspect sa rape. So, paano ko arestuhin? Okay? So, sasabihin ko, kung si Mr. Pedro, for example, Mr. Pedro, I am arresting you because of raping Maria. I have here with me a warrant of arrest. Di ba? So, sinabi ko yung dahilan bakit ko siya arestuhin. Yan, no? You have the right to remain in silent. Anything you say can be used against you in any court of law here in the Philippines. You have the right to counsel of your own choice. If you cannot afford one, the government will provide one for you for free. Okay? Did you understand rights that I have stated to you? Yan, di ba? Okay. So, hanggang dun lamang yung ating video presentation na ito, mga kapatid at mga kapangarap, at maraming salamat sa inyong panonood at pakikinig, at sana po ay meron kayong natutunan. At kung meron kang natutunan, huwag kalimutang mag-subscribe, click mo yung bell button para ma-update ka kung meron tayong bagong videos. Thank you very much and God bless you all. See you in the second video presentation. God bless you all.